Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. Welcome back, everyone. Welcome. Oh, come on. Oh, jeez. Okay, I told
you are unmuted.
Only be here. You aren't chewing wires. Okay, hang on. Judge Canoni is back in the courtroom.
Thank you. Be seated. Closing session.
All right.
22117 Commonwealth versus Karen Reed.
All right. The jury is at an impasse.
Okay. Hung jury.
So we'll bring them in.
Okay. Come here. Okay. So, welcome back. I did not really do much of an intro this time because I wanted this to be live as much as possible. And okay. No. You're going over here. Okay. But yes, as you guys know, with all of my updates on particularly Twitter and on in the YouTube community page, the jury has been at an impasse since Friday. They've been trying to work it out, it seems, and they have not successfully done so. So it does appear that we are at an impasse. It's going to be a hung jury, which means it's going to be a mistrial. I'm going to go back over some of the last updates of the things that have happened as soon as we get through this part right here.
All right, Mr. Foreman, I am in receipt of your note. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, so the court, please.
Okay, so it's official. It's a mistrial. After 9 weeks of trial in this case, and then almost an entire week of deliberation, we have officially a hung jury and a mistrial. This is a disappointment for everyone, I would think, right? Everyone wants to see some kind of a resolution to this case.
Thank you. Be seated. Close still in session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
It's a lot for the family to go through too.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m., Your Honor? And I would appear for my client.
Right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to leave for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So
What about the 19th and 9th? Is that whole week?
no, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th, any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so the court knows, Ms. Little and I are not available on the 22nd. We had a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not appear.
Okay. So you and your client will be here in person, Ms. Giannetti?
Yes.
All right. All right. Thank you. We'll see you then.
All rise.
So, all right. So that's that. Okay. This is, for those of you that are just coming in, this is officially a hung jury. It means that this is a mistrial. It means that the jury was unable to come to a conclusion one way or another in this particular case. John O'Rourke, thanks for the super chat. Just came in as I was saying that. What's going on for folks running in late? Thanks, Bytes. Yes, no problem. And thank you so much for the super chat. So, all we know at this point is that the jury had disagreement. There was at least one juror who would have wanted to convict her. There was at least one juror who would have wanted to acquit her. We don't know the numbers. We don't know the numbers at this point. We've got some questions here. Dr. Who 8675309. So they can't pull the hung jury. No, they're not going to do that because they don't. They're not going to do that in front of everybody here. To like force each individual one to say how they would have voted for these various charges. They're not going to do that. But there is an opportunity, perhaps, for the jurors to speak up and say how they would have decided. I think that's going to be up to them to decide that. Both sides are going to be very interested in that information, as are all of us, right? I mean, all of us want to know what that split was. It's going to be not just for purposes of finding out what happened, but also because of the likelihood of there being a retrial. We all want to know that. All right. So I guess now we can officially close this down. So, of course, we all want to know, what's the likelihood of a retrial, right? Because if it's 11-1, 11 would convict and 1 would acquit. That's very good for the prosecution. But if it's in 11-1 in the reverse, then that is good for the defense. And maybe the prosecution wouldn't bring a new trial. A lot of folks have been asking throughout this trial, if there is a hung jury, if there is a mistrial, would the Commonwealth bring that case again? And it really depends on a number of factors. I mean, what is the public will here? What does the jury look like, at the end of this trial? Are there things that they actually can change in order to bring about the result that they wanted? And would that be a controversial change, right? For those who are familiar with the Menendez case, for example, that is a little bit of a controversial example of a case where the first trial, murder, also double murder case, where the defendants were tried to basically more or less together, 2 trials at once. And they ended with a mistrial. And in the first trial, which also was publicized, was televised, was publicized. It was televised. In that one, they were alleging all kinds of really, really tough harms from their childhood, to include SA type of allegations. In the second trial, however, it wasn't televised, and the judge also kept all of that information out. So all of those defenses having to do with their background and their the child abuse allegations and things like that were all kept out, which is a controversial thing. I still haven't been able to look into what the court's exact reasoning was for that. But anyway, I know that it definitely raises an eyebrow for sure, because it seemed to be pretty central to the defense in that case in the first round. Anyway, so back to this case. The question really is this something that the Commonwealth could retry. Personally, I am a bit skeptical because there are some things that the Commonwealth can't change whatsoever, right? They can't change the way in which the investigation was done by the Commonwealth, by Canton PD and by the Massachusetts State Police. Those are things that those are just basic facts in this case that they can't change, right? And that all of that underpins the entire case, is the investigation into Karen Read versus other people. So, it's very, there are a number of things. Now, on the other hand, can they shore up the things that came out about, the dog bite, for example. They said that they wanted to have a rebuttal witness to Dr. Russell, but they didn't end up producing one. Maybe if they have more time, they will be more prepared for Dr. Russell to be brought back. And then they would have their own rebuttal witness that they could actually look for and find and whatnot. Maybe not. So there's a number of things here that would play a factor in whether or not this would end up getting retried. If it does and it's televised, yes, I absolutely want to be covering it. The only thing that would interfere with my covering it would be if it's, in the middle of, I don't know, some sort of personal situation, like moving across the world or something like that, something along those lines. But if it's within the next year, most likely, yeah, that's going to be a situation where I would be able to cover it. Okay, so let's get some super chats and questions, because I know a lot of folks have a lot of questions. Also, Just Because gifted 5 Legalbytes memberships at the very beginning. Thank you so much for gifting 5 more memberships. Very kind and generous of you. So let's see here. Travis James, Truth Teller, Jessica Freitag, Patricia Ann Vines, Greg Swindle. You have all been gifted memberships by Just Because. So welcome back to Bike Club. Very happy to have you guys here. And thank you so much for supporting the channel, because, it definitely takes a lot of resources, as I've said before, to put on a whole sort of trial project from soup to nuts, as we've done here with all the recaps and the live streams and everything. So it definitely helps to be able to make that a bit more of a manageable endeavor. And we're going to be doing more trials, and not just more trials. We're coming up with more VODs, videos on demand, pre-recorded stuff this week. So keep an eye out for that. A lot of folks have asked me questions about Sarah Boone, for example, how she has now officially lost her 8th attorney and she's going to have to represent herself. A lot of questions about that. So we're working on that, as well as a number of other topics, getting ready for Baldwin, everything you need to know about that one. We're going to come out with a video on that. A lot of stuff coming up. Okay. Also, Kimmy Stahl, 1975. Also, thank you so much for becoming a member. Welcome to Bike Club. Very, very happy to have you here. Thank you for supporting the channel. And John O'Rourke, thanks for the super chat here. Will they actually tell the split? I think the jury should be gagged if a decision wasn't made. That seems fair. Keep opinions secret until a decision is made. IMO. It's up to the jurors if they want to talk. I don't know. Doesn't seem to be, I don't know of any way to actually gag them, because there's some First Amendment issues there with gagging them. You've got to have some really good reasoning for that. Sean Wilson, question: if the CW retries the case and if some of the investigators are demoted / lost their jobs, could that hurt the prosecution? I mean, potentially, possibly, maybe. The other issue here is that there is this other investigation going on by the FBI, by the DOJ, that is also possibly going to result in their own indictments or something that can really complicate these things for the prosecution as well in this particular case, because they've been looking into the investigation as well. And remember, that's how apparently how a lot of this information got got its way or made its way into the hands of the defense here. Proctor's texts, I think, are one of them. People asked during the trial, how did the defense get access to Proctor's text messages? I really didn't. I didn't know, because I hadn't been following the lore of this whole case going into this. But what I since learned is that I'm pretty sure that came from the DOJ, from their investigation. So there could be more information that they get since that point in time. And that can impact both teams in terms of going into a second trial. This is such a very unique, interesting, weird situation. Wingy 158, I believe this says more about the Commonwealth than it does about the defense. CW could not convince the jury. I mean, that is true too. ZND 5th, thank you so much for gifting 5 more Legalbytes memberships. Let's see here. Jones Fox, Monica I, A Wolf of Chaos, Brimbino, Ryan Blackhawk. You have all been gifted memberships by ZND 5th. So welcome, or welcome back to Bike Club. So happy to have you guys here. And also ZND 5th, thank you so much. You've also been gifting a number of memberships. And so thank you so much for doing that once again. Let me see here. Okay. And now we've also got some other questions that are non-super super chat questions here that I want to make sure that I try to capture along the way. And okay. And some others as well. Okay. All right. I think I've got all of them so far now. I apologize if there's any that I missed. If you think that I may have missed you, ask it again, and I'll save it. Okay. Let's see here. Up to the top. John Smith, question. Weird to me. The judge sends jury back to possibly switch a not guilty verdict to guilty because, well, we really want a decision. Once the jury says we can't come to a conclusion, that should be it. The question, though, is why are they concluding that at this time? Have they really, truly worked their way fully through everything? You know, you also want to make sure that they're not coming to that conclusion that they just are basically done with deliberating prematurely. I don't think that is. I don't think that there's a problem with the way that this happened in this way. I think this is very common. The Tui Rodriguez instruction in Massachusetts is very similar to the Allen charge, which it comes from a Supreme Court case. I know that not all states do that, by the way. Not all states allow for an Allen charge or something along those lines, but federal courts do allow for it because that's a Supreme Court decision there. But basically, it is somewhat controversial because it can make it feel like maybe there's a juror that's being coerced, you know, potentially into coming to a conclusion that they really don't want to make. But here, obviously, you've got people who stood by their convictions one way or another for one reason or another. And we definitely want to know what that reason was. But I definitely get, you know, people's apprehension about like, well, they already said that they couldn't do it. The question is, could they get any closer? Genergy question, what does this mean for Karen? So this means that right now she is not guilty, but she's also not acquitted. So she has, so she's still got her bond that she's out on. She's got certain restrictions with that, undoubtedly, on travel and things like that. So that is, you know, there's some benefit to her, but she's definitely in limbo. She's in this limbo state for until the prosecution gives word that they decide not to charge her or to retry her, I should say. Because the charge is still the same. We also don't know if the jury decided unanimously to acquit on any of those charges. So this is one of those things. There was a bit that was a question about the jury verdict slip before. And, you know, as to the lesser included offenses, particularly to that second charge, because that was the only one that had some lesser included offenses there. It had to do with the DUI manslaughter charge. There were a couple other underneath. And there was a question as to whether it was proper that it basically just gave those 4 choices, either not guilty on all or guilty on A, B, or C, essentially. Like that's how it was marked. In a situation where there's a hung jury, we don't know if they would have acquitted on any number of these charges. And that's helpful to Karen Reed because, well, it would have been helpful to Karen Reed to have that jury slip form on these other charges where, it's guilty, not guilty. Well, the other two charges, sorry, let me be precise. First charge, the murder charge, and the third one, the leaving the scene of the crime. Those two both have either guilty or not guilty because there's no lesser included offense for either of those. But regardless, on all of these, wherever they can mark on a box that they would have acquitted on any number of these charges, that's really helpful to the defense because that's an indication that double jeopardy is attached, because you actually have a jury that has definitively decided unanimously we would acquit her on these particular charges, which means double jeopardy is attached. The Commonwealth cannot bring those other charges. But when they don't explicitly state that, there's a bit of an argument as to, what they would have decided one way or another, and you can't really make a strong conclusion either way. So at this point, based on how things are done here, it seems like all of the charges are back on the table for a retrial if the prosecution decides to retry it. John Smith, Legalbytes, it scares me as an American citizen that multiple people on a jury could believe the CW provided enough evidence to prove guilt beyond a reasonable doubt. I definitely understand that one. Yeah, it is. And these things do happen in criminal cases. Doctor Who 8675309. So they can't pull the hung jury? No, not at this stage, not in this venue. The Lucian, Legalbytes question, hypothetically, if a single juror disagrees with the rest for reasons that are not reasonable and they admit so to the judge during polling, what happens legally? It's still a mistrial. Tori Matthews, question, why can't they just replace the one or two people with that alternate? It's obvious that someone just refuses to look at the proof and or lack of proof. You can't do that just because they are not reaching the conclusion that others want them to. That's going to run afoul of the entire jury system. It's you've got to work with the jurors who are actually there. The only reason why you bring in an alternate onto the jury is because something happens to one of those jurors. They get sick, they have some other conflict that comes up. Something happens that they can no longer serve, and for not for reasons other than how they are leaning one way or another on a particular verdict. Because just imagine, for example, if you are the defendant and you have one or two holdouts that would have acquitted, and it's like a flipped sort of situation where basically like the rest of them would want to convict, and then because the one or two people that would have acquitted, they're like, okay, we'll just flip you out with a couple alternates. That's a serious issue as to someone's due process rights. That's a really, really serious issue for that. So we don't want to do that just because of the ways that they're leaning. That's not a proper reason to bring in an alternate. Let me get these other super chats in here as well. John O'Rourke, thanks so much for the super chat. Is this different from a hung jury per the legal definitions? If so, what's the difference? No, this is a hung jury. Hung jury leading to a mistrial. That's what this is. Grinning Llama, is there a time limit for the CW to decide to retry, or could they just leave her in limbo forever? No, they cannot leave her in limbo forever. So let me see here. Sorry, just want to make sure that I get these. Okay. All right. Sorry. Okay. Yeah, they can't leave her in limbo forever. There is a time running clock now that starts to run. According to the Supreme Court, it's like it has to be within a year. So Massachusetts law gets like right under a year. So she's got they have like something just under 365 days to decide not to decide, but to actually retry her from the date of the mistrial. So that is there's a time clock that is in fact running at this point. So we'll see what happens. Call Z, thanks for the super chat. Does the CW have a time limit on how long they have to decide if they're going to recharge or not? Yes. Okay. Sorry. I just answered the same thing. You guys were on the same wavelength there. And Wings, should jury members be required to pass basic logic tests? This is scary. Is there a McAlbert friend on the jury? Cannot compute. You know, we have to think about this from a different perspective. I know that there are about to be on social media tons of people saying that this is what happened, that somebody was close to the Alberts or the McCabe's or both, ended up on the jury. And okay, maybe that's possible, right? Anything theoretically is possible. But what is more likely here in this kind of situation is that we have someone who for one reason or another was convinced by the Commonwealth's case in chief, by the way that they put on their facts. And the better alternative for everyone who is thinking that she is not guilty and questioning how could anybody think that she is in fact guilty. The better thing to do in this situation, really, especially in addressing a potential retrial, is to look at this from the perspective of like, maybe somebody legitimately does think differently than I do. Like, this is always, anytime we have a result that we're not expecting or maybe not hoping for, it's always best to look at this as like, this is something that I can potentially learn, to see that somebody sees this from a different perspective. Like for one thing, I think that, it's worthwhile to reevaluate like the way that the defense put on their case in chief. I remember hearing some people, I don't know if you guys can hear that, but Indy's on the floor just totally dreaming. Okay. Sorry. Got distracted by the pup snoozing on the floor. So I remember hearing some people talking about how there was a risk, in fact, with the defense going putting their full court press forward on the theory that she was framed and really going all in on that. There's a risk in that the jury may be mistaken in thinking that the defense actually has a burden or has taken on a burden of proving that theory. Whereas if they had taken a more limited approach and said there's simply too much reasonable doubt here, there's like the prosecution hasn't proved their case. They cannot prove their case. And here's why, and kept their argument very, very simple. That's something to consider for the defense in considering a potential retrial strategy. And, that's something to consider, because they may have gotten confused by that. For example, they're also, it also could be that if the defense had clarified like a little bit more in closing argument right before sending them off to deliberations, something along the lines of, like I don't want to compare this case to the O.J. Simpson case, because I do think that it's different, but in the O.J. Simpson case, it was the phrase that came out of it was, if the glove don't fit, you must acquit. Like, that is something that is seared into everyone's memory about that case, regardless of how much you really know about it. You probably know that phrase. And in this case, I wonder if they had zeroed in a lot more on the physical impossibility of his injuries and her car, those two coming together, that those two cannot exist together with like the like modern laws of math and physics, that it just does not compute. That like, I wonder if that would have been clearer to everyone to say, it doesn't matter what she said. It doesn't matter what people say that she said, you know, like, because false confessions do happen. You know, even if she said I hit him, even if she did, and I'm not saying that she did, but even if somebody believes that she did, false confessions do happen. And there are some outrageous cases that have proved that to be the case, where somebody has confessed to it. And I had a video on it that I came out on that like, I don't know, like a month ago now at this point, where literally a guy confessed to killing his father, and then his dad walked through the door. He wasn't even dead because he just was tortured through this interrogation process. So, you know, there are ways that they could have possibly combated the strategy by the by the prosecution in different ways. And this is 100% Monday morning quarterbacking. You know, like during the trial, I loved their strategy, but at the end of the day, the best strategy is the one that wins. And so, you know, this is something that we can criticize one side, we can criticize another side, but at the end of the day, the one that is the correct one is the one that gets your side the win. So you know, it's definitely a time for both sides to be reevaluating their strategy and to figure out, you know, where they can improve things for the next round, if there is another round. Okay, let me get some more questions here. Craig, thanks for the super chat. Thanks for all your coverage on this trial. What's the likelihood we find out the count if jurors on the guilty side versus not guilty? You know, I don't know the likelihood, to be honest with you. But thank you for the kind words and for the super chat. But yeah, the likelihood we find out, I don't know. I don't know, but I definitely am curious about that for sure, because I think that's I mean, yeah, we all want to know that question, right? That's like the $1 million question. It's like, you know, what was the split? Who was it that split? But of course, you know, the other thing though is, if I'm a juror on this particular jury, I don't necessarily want to be identified to the public because of the huge circus that came out on this, at least not anytime soon, for all kinds of reasons. Whether you were somebody who would have acquitted, I'd be concerned by, you know, people in Canton doing one thing or another, you know, certain individuals possibly, you know, or if I'm on the other side, there is a very loud group of people who are very passionate in defense of Karen Read as well. You know, I'd be concerned about that, you know, and the jury has heard through some of the witnesses that that there was harassment, for example. Now this is another, well, no, it's not, there's not a conviction. So appealable error, I was going to say there's appealable error here because of the harassment coming in. But anyway, so yeah, I don't know what the likelihood is, to be honest with you. Coach Feeds, I'm sorry if I'm mispronouncing that. Is this one of the few cases that if they go to retrial that they could really consider change of venue? I mean, yeah, I think so. I think there is a possibility of that here because of the fact that I mean, this has been a huge trial locally, of course, and now they actually have paneled a jury, and it's been all over the news, and everything that's come out at trial has been all over the news. Like I could see that. I could see that requiring a change of venue in this particular case now if there's a retrial. Odin's Martyr, thanks for the super chat. Could the defense have pursued all the same lines of questioning had they not claimed a frame job? Can the FBI/DOJ now use that testimony? That testimony can definitely be used for sure, because if it's related to their case, yes, because that is testimony that was given under penalty of perjury. Yeah, they can use it in their case for sure. And Yeah, as to your first question, I mean, well, there is a certain there's a certain weirdness about those taillight pieces, right? If you don't think that she was framed, it is hard to square that with the taillight pieces for sure. But like, here's the thing though, is that as the defense, you also could say, okay, there's all of this going on here, right? You've got all of these arguments here. We think that she was framed. Even if you don't think that she was framed, narrow this down. This has been a long case, but it really comes down to one thing. Did she hit him? No, she didn't. And here's why. And so the defense could have potentially sort of simplified what otherwise was a very big mess of information and arguments and things from the Commonwealth, and said the reason why their side is so complicated is because they don't have a case. They're just trying to obfuscate with smoke and mirrors. That's what they're trying to do here. But this is really simple. They can't even prove to you that she hit him. And here's why. So anyway, let's see here. Okay, so let's get some more questions here. I know so many people have questions here, and it's been a good week since we chatted too, unless you of course are a member of Bite Club, in which case we were able to chat on Friday. Colin Murray Bain, Legalbytes, if there is a retrial, would there most likely be motions to delay due to the Fed investigation, or does it link with the previous decision to go ahead by the judge? Well, like as I said, there is a 1-year time limit, so there's only so long that they would be able to delay anything here. Tori Matthews, question: can the CW lower the charges in hopes that the jury will go for those over murder charges? They can choose to pursue some charges and not others, if that's what you are asking. They can do that. All right. Call Z, did we wrap up the Lally tally? So, oh gosh, I actually never got around to confirming specifically what it was. 2017 was the final number total. I would knock it down to about 2010. That's probably what I would knock it down to. 2010, maybe 2012, because there were a handful that were delivered at the very end by the defense team when they were on direct for their witnesses. Natalina Rose, what do you think the main hold was for the jury? I think that their main hangup probably, if I were to guess, I mean, and I don't have any specific information on this. None of us do at this point, not until any jurors decide to come forward and talk, right? So, but this is just me sort of speculating a bit. Main hold for the jury, I think that for anyone that was pro-defense, most likely came down to either they believe that Karen Read in fact was framed, or they looked to the expert evidence and said, the physics doesn't match with the medical testimony. It just doesn't match. And then on the other side, it probably would have had to do with the fact that it probably would have had to do with the fact that they thought that Karen Read made an admission, which is hard for somebody to get out of their mind when they think that somebody has made an admission to something, regardless of whether or not it's a real admission. So that can be really hard. Like I said, I'm basing that off of really when I've seen other people, okay, sorry. I'm seeing, on social media, people, when they talk about why they think that she's guilty, it usually comes down to that. It's that they think that she has made an admission, and they can't look beyond that, basically. Okay. Now, also, 7 minutes ago, I can see here, it's been tweeted by the journalist from the courtroom. Commonwealth has announced they plan to retry the Karen Reed case after hung jury today. There will be another trial, according to the DA's spokesman. So there apparently will be a retrial. Now, assuming that is televised, which I don't see how it wouldn't be televised, because they would have a much harder time with people being at the courthouse, right? That was one of the big reasons why the Johnny Depp trial was televised, is because they were like, look, there's going to be so many people trying to get in here every single day. It's going to be a total madhouse around the courthouse. And by the way, there's also other cases going on at the courthouse at the same time. They all have due process rights too. So that was one of the big reasons why the Johnny Depp trial was televised. And yeah, so I would imagine the same logic would apply here, especially now. Man. So apparently they are going to be retrying. That's wild. All righty, going on through some more questions here. Okay. Tori Matthews, can CW lower charges? Oh, yes. Okay. Yes. As I said, they can choose which ones to pursue, but it sounds like they're pursuing all of them. Mariana Vieira, question. So if the CW doesn't prosecute again, that was just it, nothing else happens. That would be what happens. But apparently that's not what's going to happen here. And Legalbytes, is there a time limit for the state to decide to retry, or is it only limited by statute of limitations of relevant crime? No, like I said before, they've got within a year of the mistrial. Walt Dog 5791, question, would the judge put a gag order on the jury in court, or is she going back to the jury room and possibly doing it there? I am not sure. I don't see the judge putting a gag order. The judge would need to first consult both attorneys before doing that anyway, and have a whole back and forth between them. Dionysia Jaclo question is Karen is free until and if retrial. I mean, kind of, sort of. Like, she's on bond, so she's not quite free, but she's out of jail at this time. Tori Matthews question, doesn't this work as innocent until proven guilty? Obviously, the CW couldn't convince the jury that she's guilty, so she isn't. At this point, yeah, she has not been found guilty by any court of law at this point in time. Fuel and Ivis, thanks for the super chat. This is as crazy and drama-filled as House of the Dragon. It really is, except that this is real life. Can you imagine? Oh, man. Doctor Who 8675309. So what will we have more of? Andy Lally's what if any's, or Morrissey's vicious glasses attacks in the Baldwin trial? Seems like we're getting both, you guys. Just as a reminder, July 9th, the Baldwin trial will be in jury selection, and on the 10th, they are supposed to start opening statements. So we are going to be right back here with a whole brand new trial. That one's supposed to be way shorter, however. So that, I mean, the judge said that she wants it out by the 19th. Like, she wants, like, basically trial to be done by that point. So that one's going to be lightning fast, especially in comparison to this one. So that's going to be the next one to look forward to. But in the meantime, as I said, there are there's more content to expect on this channel in between then. All right, Flashman 85. I have a question about Sarah Boone, but I'll wait till members only. Fair enough. Justin Perry, question, can you see the defense changing their strategy or put something into evidence that wasn't used in this trial? Yeah, I don't know about them putting something into evidence, because I don't know what else they have other than what they've put in front of the jury. But I will say that I can see them changing their strategy if that's what they decide to do. Maybe not going as hard in the paint on the issue of, on the issue of, sorry, I'm doing multiple things at once. The framing argument, maybe, hit the argument, but like I said before, but like really make it like, if you are at the center of this target, you don't have to agree to everything else, but if you are here, you are acquitting. Like, if you think that there's any question about whether or not Karen Reed's, SUV damage matches the injuries to John O'Keefe's body, if you have any legitimate question about that, then yeah, you should be acquitting. You have to acquit. Yeah. Okay. Let's see here. Coach Fides, doesn't the prosecution hear the noise of their poor effort and think we need to rethink this? I don't know. I don't know. There have been a number of things that the prosecution has done here. That I don't quite understand. But hey, they're going to do what they're going to do, I guess. Kings and Queens, thanks so much for becoming a new member or returning to YouTube membership. Very happy to have you back. Thank you so much for supporting the channel as well. Justin Perry, question, can you see the defense changing their strategy or put something into evidence that wasn't used in this trial? I just answered that one. Okay, Grizzly, Legalbytes, if this case gets retried, can statements given by witnesses be used? They can. This is another question is, will all of the same witnesses be called? And if they are called, will all of them be available to testify, as an example? There's always a possibility that, witnesses disappear. That sounds like so nefarious when I say it like that. But, something happens, a witness can't testify anymore for one reason or another. They're unavailable, right? That's technically the term for it is, a witness is unavailable to testify. You can technically use their testimony from before. This is how, for example, in the Johnny Depp case, there were a ton of depositions that were played in that trial as well. It definitely felt like death by deposition, but they put those witnesses on in that way. So that is also possible. TJM, think Lally or someone else steps in for retrial. That I really don't know. All I know is that the DA's office in general is planning to retry this. Man, but thanks for the super chat. Alaksar Sidaran, thanks so much for the super chat as well. I'm not sure if you meant to add something to that, but I'll try to keep an eye out for that just in case. I know, because sometimes people send in a super chat and they meant to, there it is. Yep. There it is. Forgot to write my message. Haas Long for KR to get a book deal. I don't know. She hasn't been convicted at this point. So, profiting from the trial is not, I don't know what Massachusetts has in terms of son of Sam laws, where you're not allowed to profit from your criminal conviction. That is a pretty widespread rule in a lot of states, but at this point she has not been convicted, so maybe that's something that could help her legal defense funds, which I would be certain are insanely expensive already, and who knows what she would have for that. Sandy, thanks so much for the super chat. And also one of our awesome mods. Legalbytes is less than 2K away from 250,000 subscribers. Please subscribe and share her content. Oh, thank you so much, Sandy. Thank you so much. And yes, we are on the road to 250K. We are at 248 and some change. Let's see here. Where are we at? Let me refresh this. 248,476. So if you guys are new here and you haven't done so already, and you are interested in more, there's got to be more Karen Reed coverage now, right? It's not something that I thought was going to be continuing after today, after 9 weeks of this trial. But if it's going to continue, we've got to cover it. So if you want to, continue that, as well as other great content that's going to be coming up on this case, or on other cases, I should say, on this channel, definitely subscribe. It does help our overall growth. So thank you so much for that, Sandy. TJM, thanks for the super chat. What, if any, regrets must Lally have? Har har. He might have a few. Mr. W, thanks for the super chat here. If you had to retry this case as a CW, how would you do it? Also, same for the defense. What would you change? By the way, wife and I called mistrial. Well, all right. So what would I do if I were the Commonwealth? I would cut out at least half of their witnesses, because all they did with all those witnesses was to bring in some inconsistencies between those. So that's something that I would do is that. And I would also completely get rid of Trooper Paul as an expert in this case, because it's just entirely laughable that he's any form of an expert here. And I would bring in somebody who actually can use physics and science and math and things like that as an expert to try to give some sort of a plausible explanation here. But they still have a lot of major issues here. For example, the medical examiner's testimony. Like, what are they going to do? Get a new medical examiner who can't examine the body, but is going to go off of the medical examiner's notes, who, by the way, originally said, that the manner of death is undetermined. Like, that's still, even if they got a new medical examiner to come in and concludes otherwise for the Commonwealth, they still have this problem where the defense can come in and say, okay, but the original medical examiner said otherwise, right? So like the Commonwealth is just trying to bring in an expert until they get the result that they want, as opposed to just relying on what the actual evidence says in this particular case. So, that's one of those things. Let me get some more questions here. And then in terms of the what the defense should change, what I would change if I were the defense is I would make it clear that I'm making like a multi-pronged attack to say, this is a frame job. But even if you don't believe it's a frame job, it's all of these people. But even if you don't believe that, we still win if you believe this. And we still win if you believe this. And we still win if you believe that the investigation was crap and that they did not come to, a proper conclusion on the other side, and that they can't prove their case because of XYZ. Like, at the very center of that target is the idea that Karen Reed did not hit him, that she couldn't have hit him. Like, that would have been the thing that I would have really, looking back on it now, of course, like I said before, this is 100% Monday morning quarterbacking. Like, the defense otherwise put on an incredible case. But, I think I would have really drilled that home, that, like, if nothing else, like, if you think that the prosecution has not properly proved that she in fact hit him, you have to acquit. Kings and Queens, 2,000 more. What if anything? I know. I really hope not. I sincerely hope that Lally, of course we ended up having fun with it, of course, with the Lally tally and all of that. But I legitimately hope that is something that someone has a conversation with him about it and says, look, you're driving people nuts with that. And that he figures out a way to unlearn that habit. And I say this as someone who struggles with ums and uhs, and I get comments in all my videos on all of that all the time. I've gotten better with it. I used to be a lot worse with it. However, there you go, Indy, get rid of that pillow. However, I say that with full awareness of my own limitations. I will say, as somebody who's trying to listen to the questions, it is so difficult to follow along. How is the jury supposed to follow along with you if they cannot follow even your questions? So, I sincerely hope that he does take that to heart and changes his style just as a practicing trial attorney. Heather Miller, thanks for the super chat. If Lally has another job in different office by the time of a new trial, can he be called as a witness? If so, could he be questioned in evidence that wasn't admitted? If Lally has another job in a different office, possibly about the whole Sallyport thing, but that could go into I don't know. I haven't thought long enough about that one. About the whole, like, could he be a witness? Because I've seen this about, him possibly being called as a witness in the stuff related to the Sallyport situation. I mean, because there still is a work product immunity and an attorney-client privilege sort of situation possibility with regard to like his communications and his work behind the scenes in putting on this case, regardless of whether he's still working for the DA or not. So that wouldn't be impacted by him not being there or being there still. Either way. Dan Leach, thanks for the super chat. Watched 12 Angry Men last night. Sad about hung jury. I know. That's a great movie too. Alexis Darin, thanks for the super chat. What are your thoughts on the Albert and McCabe families sitting behind the O'Keefes? Are the O'Keefes going with Lally's theory? It seems that they are supporting the Alberts and the McCabe's. The Alberts and the McCabe's. It seems so. So that to me was an indication at that point that the O'Keefes actually are supportive of that side. So fair enough. Stella by the Sea, thanks for the super chat. But anyone who replaces T. Paul will actually believe in math and science and won't be able to construct something so illogical. Lally's trapped. I agree. I mean, and then to come to the conclusion about the dimpling on the what's it called, on the tail light, that caused the scratches on his arm. I mean, it's just so laughable. It's so laughable. So yeah. Rising Sunfish, thanks so much for the super chat. To quote my grandma's cross stitch, if you can't dazzle them with brilliance, baffle them with BS. I think the CW did this intentionally. If Lally returns, feel free to use the art I tweeted at you, by the way. Oh, thank you so much for that. I appreciate that. Yeah, I actually have a t-shirt that says that. If you can't dazzle them with brilliance, baffle them with BS. That is the motto for the prosecution's case in chief here. Coast Ghost, thanks for the super chat. If current DA does not retry, can a future DA retry? Only within a year. But the DA also apparently put out a statement recently, just like very recently, that they do intend to retry. Kimmy Stahl, 1975. Let me see here. Sorry, I just want to make sure that if there are other updates on this. Okay. Okay. Sorry. It says my dad grew up around the corner from the Alberts. He said apples don't fall from the tree. Interesting. That's very interesting. I'd be curious to hear what kind of stories your dad has with them. All right, let's get some more questions here. And one more super chat. First, just because, thanks for the super chat. To quote Loud from the Matilda musical, the less you have to sell, the harder you sell it. The less you have to say, the louder you yell it. That is perfect. That is perfect. All righty. Geeky Nerd Demon. Did you see that Logan Paul has sued CoffeeZilla? Yes, I did. I haven't had a chance to take a look at it, but that is one that I am very interested in digging into this week and getting something out on it as well, because I made a couple of videos when he threatened to sue him for defamation, and I think this is also on defamation, this actual lawsuit. So I'm very, very curious to see all of that. Reputational harm, Logan Paul has reputational harm because of CoffeeZilla. Come on now. That's one thing. Also, where's the false statement? Also, he's got to show actual malice. Those are my initial thoughts on any kind of a defamation claim by Logan Paul against CoffeeZilla. But yeah, I'm going to have to dig into that for sure this week. Thanks for that. The Lucian Legalbytes question: I would be surprised if no juror decides to make some interviews on the deliberations. With that said, how detailed can a juror get into during post interviews? Can they name other jurors? Well, so this is something that also can happen. Is the two sides, the two legal teams can make themselves available basically for the jurors to reach out to them and to call them and give them information. For example, I remember Natalie Wisco, defense attorney for Kyle Rittenhouse, telling me about how there were some communications that they were hoping to get from jurors, and she was explaining to me how oftentimes they will call in and they'll give all kinds of information. So they can, and that can be very, very valuable for either side to get, regardless of whether they win or lose, because that can also impact how they look at putting on other cases moving forward also. So, in this kind of a case with a hung jury, actually, I wouldn't be surprised if the people that would have wanted to acquit, like, actively decide to call the defense team to say, like, this is what worked for me. It didn't work for others, perhaps. I'm not sure. It wouldn't surprise me. And the reason why I think that is because they probably are very frustrated by the fact that they were not able to give their conclusion and their decision in this case. Let's see here. Oh, okay. I sent you the Court TV video that I watched about Black Swan. Oh, yes. Thank you for that. Alaksar Sidaran, sidebar. What's the next trial you're covering? Like I said before, Alec Baldwin. Alec Baldwin is a trial that I'm covering. That is going to be, let's see, a week from tomorrow is jury selection. So a week from Wednesday is opening statements. So definitely join me for that one. That one's going to be a big one as well. For sure. Okay. Oh, the defense gave a press conference a little while ago. Okay. Let me see if I can find that. All right. It's not coming up immediately. Well, let me see. Karen Reed, defense press conference. Okay, here's a little bit of a blurb here. I mean, this is only like 48 seconds. So this one, let's see. Let's watch this really quick. Okay.
They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit.
Alan, you're going to stay on? Working with Karen?
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
Okay. All righty. So, okay. Let's get some more questions here. The Lucian question: I would be surprised if no juror decides to make some interviews. Okay. With that said, how detailed can they be? We already answered this one. Ashley, question for the chat. My name is Green now. Why? I don't know if the chat answered this for you, but you are now a member of the of Bike Club thanks to, I think it was Just Because, that it was either Just Because or ZND Fifth. Both of them gifted some memberships today, so you've been gifted one for the next month. So you can join us with perks. You can check in the chat, for example. You now have the ability to use some emojis that are member specific, and you also can join us on Friday for our members only live stream, as well as other perks like early access to uploads and all that kind of stuff. So good stuff going for the next month for you. Ethan Morgan. So this, it wasn't a question, but I saved this earlier because there was something here that was interesting here. Ethan Morgan says, a former prosecutor in the Mass DA's office, Shannon McMahon, indicated last night that she thought the DA might be in a tight spot since the allegation is intentionally killing a cop. She thinks he might be forced to retry in order to save face. That also could be. It also could be that they're just like, well, he's a dead cop, and so we have to keep pursuing this until the end of time. Yeah, I guess I can see that too. Doctor Who A675309 CW has said they will retry per Michael Morrissey. That is correct. Brimbino, Legalbytes, sorry, I'm at work, was gifted a membership by someone. Sorry, I didn't see it. Who did it? Whoever did it. Thank you so much. Big fan of this channel and can't wait to binge all the other member perks. Lovely, lovely, lovely. Very happy to have you here. Shiny Stones, Legalbytes, do you think they will try even, they will find another 12 jurors that haven't heard about this absurd case by now? That's the struggle. That is one of the big struggles here. Because, yeah, if they thought it was going to be hard to try this case in the Boston area before now, it absolutely is more difficult now after this trial, because how many people didn't hear about the trial before, or didn't hear about the case before, and then in the midst of the trial joined in like, what is this? This is crazy. I need to hear about this. So yeah, that's a big challenge here. Stephanie Rivera, Legalbytes, I find you after learning about this case and have watched all the recaps and many lives. I've enjoyed your commentary and learned so much. Looking forward to the next case. Well, thank you so much. Thank you. Yes, I hope you do stick around for all of our upcoming content. Young Kook Sim, sorry, I hope I pronounced that right. Question, but if they decide not to do a retrial, will she be acquitted? I mean, she wouldn't be acquitted, but she just, the statute of limitations would run out and she wouldn't be able to, or she would end up, just because of the process of time, she would not be found guilty by anyone. So, all right. Moving on down. Ashley, question, Legalbytes. Anyone familiar with the defense having a defense team fund people can donate to? Saw a comment about it on Reddit and it's on Yanetti's website. I am not too familiar with it. I know that there has been some crowdfunding on her behalf. I don't know, if that's still ongoing. I would imagine at this point, there probably are a lot of people that are interested in donating. For sure, because, just after having watched this case and everything that she's gone through. So yeah. But yeah, I guess his website, I'm sure there are some other places to find them, but I don't know specific places. And to Legalbytes, different perspective. Some people with doctorates used physics, and the state trooper spoke to the crime scene and used psychics. Yes. But what I'm talking about with the different perspective is that, keep in mind that as you guys have been watching, I've also been commenting. And so, I've been commenting, other people have been commenting, Emily D. Baker, Ian Runkle, Peter Tragos, like all of these people have been commenting, as well as other like just, true crime channels, for example, that are not even lawyers, but just, they've been giving their take on it. People have been talking about it. People have been deliberating over the last 9-10 weeks in this. And, and so people have been coming to their conclusions amidst that whole conversation. So the jurors are in a very different situation, right? Because they don't necessarily, well, they certainly should not be going on social media and hearing about the case and, watching any amount of content on the case. They're not supposed to, they're not allowed to. That's something that will get them kicked off the jury. And I remember, one thing that has me thinking about this a bit too, about, the commentary on these trials and how much people understand them due to the commentary that people give. There have been people who have commented on some of my videos saying, thank you so much for these recaps. You've been so helpful in helping me to understand what's even going on in this trial. Because if I were just by myself, I would have no idea what's going on. And, you have to think about it. The jury is in that boat. They don't have anyone that is explaining to them the process. They don't have anyone that is, calling balls and strikes, so to speak, as I like to sort of describe what it is that we do, talking about different objections, talking about why the jury can or can't see something or hear something, or, there are, quite a few things in the process that can be very confusing for a juror because they just don't have anyone to explain that to them, because they're not allowed to have someone explain things to them for all kinds of reasons, right? Like it would be improper for someone like me to be in the courtroom telling the jury this is what's happening, even if I'm supposed to be like a middle of the road person explaining these things. Like, that's the judge is in that role. How many more people do you need in the courtroom they're going to be, playing sort of a role where they are, supposed to be totally unbiased, supposed to be, just explaining things to them. I don't think that's a good thing necessarily to have someone in the courtroom like that. But, so how many people in that jury box were sitting there throughout the trial and feeling like, I don't quite understand what's happening here. I don't understand the significance of what's going on here. Whereas like those of us watching, are interacting with one another and catching things that we otherwise wouldn't have seen because we saw that somebody else caught something. So yeah. So anyway, so there's a number of things that could have been factors here. Timmy Faison Cook, does Lally have to be the lawyer that prosecutes the case next time? No. Nope. Rosemary Compton, question: if a change of venue is requested, what are the limits to the change? Example, does it have to stay in the state/county? Well, it would change to a different county, but it would stay in the same state, is my understanding. I mean, I've never heard of anyone. No, if it's a venue change, it has to be in the same state. Patrick Barrett, Legalbytes conspiracy theory warning, but is it possible that the McAlberts could have somehow used their influence to plant a juror? I'm highly skeptical of that possibility. I've heard people, saying that was a thing that they thought was happening. I'm highly skeptical of that because of the jury selection process. Both sides play an equal role in that, and unless there's some information that somebody was withholding that they did not provide, that's the only way that I can see somebody. But like, there were so many days of jury selection though, that like the likelihood of someone getting on that was a plant and like going through that whole process just seems so slim. Like if they had like, 24 people come in to jury selection and they selected 12 of those 24, the likelihood is pretty high. But like, this was days of jury selection. Remember, I mean, it was a very, very long time for jury selection in this case. And, I can't remember how many, like hundreds of people came into the courthouse during that time to be a potential juror in that case. Like the likelihood is just so slim, just looking at the numbers even. Justin Perry, question: can the defense use testimony from this trial to hold the witnesses accountable at the other one? At the next one, like they use the grand jury test? Yes. Yep. It can still be used to impeach. Absolutely. Right now and not later. Question: Judge Bev's brother represented Chris Albert for a hit and run homicide in 1994. How was she allowed to preside over this case? That is, if she had represented Chris Albert, I can see that being a reason to have her recuse herself. However, lawyers take on all kinds of different cases, and a case that her brother took on, I don't know. I that one doesn't seem like that's close enough to require a recusal. Like if it was she's the one that represented him, and therefore she has all this confidential information about Chris Albert, for example, and then she's forced to make decisions about evidence as to him. I just it's that's where things get really, really murky. But her brother representing him, nah, I really don't see that as an issue. But I do understand where people have their concerns about it. Ashley, Legalbytes also think I hit him versus I hit him. We don't have any audio of anything outside KR's voicemails. No one knows what was actually said or how it was said outside of VMs. Yes, I agree. That's like my cousin Vinny, right? Where somebody testified that he made an admission, and it was like, like what was it? Like, you shot him, and he said, I shot him. But the statement was posed as if it was an admission, where there was a question mark after it. And she has been insistent in other interviews. She's been insistent that she had a question mark at the end of that statement. It was preceded by a question mark. It was preceded by a did I. So that's definitely what she has insisted on. So, it comes down to how much credibility you have in the people that say that they heard her say that. Ethan Morgan, question: what is your take on this court not allowing testimony read back? That's typical. The jurors have to rely on their memory. That's why they're allowed to take their notes with them. Yeah, no, there are a number of issues that can come up with allowing for testimony read back, because you can have different interpretations based on like the way that the testimony sounds when it's read back, as opposed to when you hear it, see it live. Even the difference between seeing it live through a live stream versus seeing it live in the courtroom can be different, because there are like there's like the mood of the room, that can play an impact, like almost like a vibe. I remember talking with Natalie Wisco going back to the Kyle Rittenhouse trial, when she was talking about, I asked her about what the room was like when he was on the stand and he broke down crying. Like what was it like in the room at that moment? Because for us, it seemed like it was a very powerful moment, those of us that were watching it live through the live stream. And she was like, yeah, you could hear a pin drop. People were not breathing in that room because they were so silent watching him. And it was as if like you could feel like a certain electricity in the room because of the testimony that he was giving. You could feel his emotions, basically. And that's something that you don't get on a live stream. So like even just those two compared, and being able to see it on a live stream is amazing, because you can see so much detail about what is happening inside that courtroom. However, even that is impacted by where that camera is pointing. For example, when you're sitting there, you can also look around 360-degree view anywhere you look. You can take in information about it. So when you're reading from a transcript, however, and I say this as someone who has experience reading a transcript record into a trial before, where I was I was expressly instructed by the judge at the very beginning of reading this testimony into the record that he was like, basically like, you're not allowed to read this like a human being. You have to read this like a robot. Because otherwise that can be prejudicial to whatever side. And so I had to read it literally like a robot into the record of this one trial that I was helping out with. And it was not the same as hearing someone speak their testimony to a jury or in a deposition or anything like that. So reading back testimony can have its own problems too. Mariana Vieira, Legalbytes, if the CW decides not to retry, that is it. Her charges are dropped and that is it. That would be it. That would be it. But as we've said before in this stream, the DA is, they are choosing to retry. They've already said so. Flashbang 85, if there is a retrial, can both sides use testimony from trial 1 to impeach a witness? Absolutely. Brody, Legalbytes question, could the FBI stop the case being retried? They can put forward information that would, maybe change the mind of the prosecution in terms of like, will they or won't they retry? But they can't do anything to interfere with the legal process there. They can't. Daniel Nagy, Legalbytes, can the defense file a motion to dismiss based on the hung jury, meaning the CW failed to prove their case beyond reasonable doubt? No, sadly, no, they can't. Has 01, Legalbytes, do you see anyone reporting if Paul O'Keefe said anything to KR as he was leaving? It looked like he said something to her. I have not seen that. I have not. But if I do come across something, I'll definitely let you guys know. Debbie Faison Cook, same judge as HDR for Alec Baldwin. Yes. So the two Rust criminal trial cases have the same judge. That is Judge Mary Marlowe Summers. So the same one who tried or who presided over the trial against Hannah Gutierrez Reed. Excuse me. Diaphragm issues. The same judge who presided over the trial against Hannah Gutierrez Reed will also proceed against Alec Baldwin or preside over the trial against Alec Baldwin. So yes, same one. Marmite question, will there be a different judge if a retrial? Possible. My guess is probably not. But it is possible. DeLorean, Legalbytes, if I'm not familiar with the jury system, but why can't the judge make a decision after a hung jury? Because that decision is ultimately up to the jury. There has to be basically an extraordinary reason to take that away from them. Let's see here. I just want to make sure that I've got all of these. Okay. Just Che things. I think just Che. Question, can the judge say no to another trial? Nope. No, she cannot. Flashbang 85 question, do you think Judge C will step down because of the huge pressure on the defense wanting her to recuse from trial 1? I don't see her stepping down just from like public pressure at this point. I don't, the only way that I can see her like not being on this case is like sometimes there's a rotation of judges, and so cases will get rotated to a new judge at some point in the litigation. It happens. It happened, as an example in the Sarah Boone case, which has been in pre-trial litigation for 84 years. But it seems like it's going to finally proceed in October now that she's going to have to represent herself. Crazy case. So, yeah, I don't see her stepping down. Daniel Nagy, Legalbytes, can the defense claim prosecutorial misconduct? Sorry. Prosecutorial misconduct based on, for example, the inverted Sally Port video and the baseless things Lally mentioned in his closing argument. Well, that's something that they would probably do if there is a conviction as part of, part of their appeal, more like. Janet G, Legalbytes, don't know if you covered it. If they do this trial again and it's another mistrial, Is there a time where the courts say enough, no more retries? That's a good question. That one I don't know. I've got to ask some folks that are. I've never encountered that kind of a situation. I should ask some other attorneys who have practiced in criminal law, because that's a very interesting question. I would imagine at some point there's a rule for enough is enough. Let's see here. Okay. Mariana Vieira, Legalbytes, what happens if KR does not have money to keep paying her defense team? That's a really tough question, because then she might have to hire a different defense team that's, less expensive, or I don't know, because typically, like, if you've gone far enough, with being represented, then suddenly saying that you're indigent, I don't know. She could, if she truly does become indigent as a result of result of this trial, and then she can't pay any more defense bills or attorney, fees or anything like that. She could end up with a court-appointed attorney. She does still have a Sixth Amendment right to an attorney. This is a criminal case after all, and this is at the trial court level. So I guess she would have to be appointed one is the issue. Divine and Hale with Donna Clifford. Question: if this will be retried, can Karen move from this area if she's out on bond? She's gonna have some geographical restrictions still while on bond. Sleepy Sloth. Question: how many times can they retry if it ends in another mistrial? That I don't know. I don't know how many times, but there definitely is going to be a limit. Megan Rose, Legalbytes, is it too popular of a case to retry? I mean, finding a jury after this one is going to be really tough in a retrial. I don't know. So yeah, I don't. There, you may have a point there. Bermino, Legalbytes, as a resident of Massachusetts, should I be upset about the CW wanting to retry this case? It seems like a waste of taxpayers' money. Or does my taxes not go to DA to try cases here in Massachusetts? So, I actually don't know about the allocation of taxes to particular DAs, but I would imagine it comes from county funds. So, the DA is county-wide. So I would imagine that if you live in that particular county, your funds do pay for that. So if you don't live in that county, though, I don't think so. Most likely not. Divine and Hale with Donna Clifford. Question: can the new jury know this already went to trial? I don't think so, because I think that would be prejudicial. So, yeah, probably not is my answer to that. And Legalbytes, can the defense use Trooper Paul's rubbish testimony in this trial to point to their original explanation, even with a new expert? I mean, they could call him as a witness. The question is, would that be a good idea? Would that work out so well for them? I don't know. It might be kind of an awkward and clunky sort of direct examination to bring him on. But I mean, they could bring him on to talk about like the initial investigation, in terms of like what he did in investigating the car and or examining the car and all that kind of stuff. So I don't know. I mean, they could call him as a witness. The question is like, how would that work out for them? I'm not sure. James Games Classics, Lita Haas, many trials can they bring if it keeps getting hung jury for the next trial? I know this question was brought up a lot, and I actually don't have the answer to that. But there's, like I said before, there definitely is a limit. Ashley Roman, question. So they're already saying they will retry. Such a waste of resources. Yeah. Flashfan85, question. Do you think Jackson and Yannetti will remain as KR's attorneys? that was a question that was asked of them during that little blurb that we watched earlier of the press conference, but that the defense had, but they didn't answer it. Here is also, let me pull this up real quick. Okay, I'm going to show this on the screen. So Angela Levy from Long Crime Network posted this to Twitter. Statement from Norfolk District Attorney Michael Morrissey. He said he intends to retry Karen Reed. So this is the actual statement here. A mistrial has been declared in the matter of Commonwealth v. Karen Reed. Judge Beverly Canone set a status conference date of July 22nd, 2024 at 2 p.m. in the Norfolk Superior Court. First, we thank the O'Keefe family for their commitment and dedication to this long process. They maintained sight of the true core of this case to find justice for John O'Keefe. The Commonwealth intends to retry this case. So that's the full statement on this. We don't have any other information from them. All right, some more questions here. Samantha, Legalbytes question. I live near Canton. You can't go anywhere without seeing something about this case. People have bumper stickers for free KR. Will they move the retrial? I could see it happening. I don't know if they will for sure, but I can definitely see it happening. Ashley Wynn, Legalbytes, sorry if you've answered this already, but if there were a retrial, are the lawyers barred from mentioning anything from this trial? Do they behave as if this first trial never happened? Well, they wouldn't be able to talk about the specifics of this trial, but they can definitely bring in testimony from it to impeach, for example. So they don't have to pretend it doesn't exist, but similar to, when they're like, oh, you testified at another hearing, oftentimes they were referring to a grand jury hearing by the DOJ. So they couldn't say specifically what indictment hearing it was, but, it was, or what grand jury hearing it was, but that it was a grand jury hearing. All right. Mark O, Legalbytes, seems like a mistrial win for defense. Why? Well, it's better than a conviction. There's a little bit of a win there, but it's not so much a win because of the fact that it's not an acquittal. It also means that Karen Reed's going to have to spend a ton more in legal fees. It also is a major, major stressor on her and her overall health and, her overall life, her family. Just there are so many even hidden costs to being a party to a lawsuit that actually even before it goes to trial, it can impact all of your relationships. It can, so many things. So your employment can get impacted by it. So there are so many issues for her moving forward with having to proceed with this case again now with a mistrial that. It's not exactly a blessing for her, but it is at least not a conviction. And the prosecution has to start from the very beginning now with their case, their theory. They're going to make whatever strategic changes they decide to make. Who knows what those will be. If any. What, if any, changes are they going to make? I don't know. Daniel Nagy, Legalbytes, can the defense file a motion to dismiss based on the outcome of the trial? Hung jury equals CW failed to prove beyond reasonable doubt. No, unfortunately, no, they cannot. Flashfan 85, Legalbytes, do you think the DA will try the case himself? Oh, that's a question. I don't know. I don't know that I don't know. That's a very interesting question. I don't have a good answer for you. All right. Logan, Legalbytes question. If it was retried in the same area, would Judge C preside over it? Most likely. There could be a change, but I think most likely she would be. Bluebell question. Alita, do you think the verdict could have turned out differently if the judge would have given the prosecution and defense the postponement they requested? Oh, yeah. There's definitely a chance of that because I think that the reason why they both wanted to postpone it was because of the FBI investigation. So whatever information came up during that investigation that they didn't have the ability to use in this trial could have impacted the outcome of this trial for sure. To Bleach fans question, so what happens to Karen Reed? Same as before, she's out on bond. She's got a lot of bills to pay with these attorneys. Now they just start from square one again. Aunt Pity Pat Hamilton question, did they announce the split? Nope, we don't know the split. Flashfan 85, Legalbytes, I promise I'm not trying to be offensive to the state with this question, but I've seen this happen before. Do you think they will try dirty tactics in trial too? Yeah, I'm right there with you. I hope not. I sincerely hope not. I do hope that they put on a clean fight this time around. There were some things that I noticed that were dirty in this case that I did not like. But hopefully they don't do that second time around. Sandy, Legalbytes question from Jones Fox member. How many mistrials can they have if they go forward with the jury is hung again? Can it be an unending process of retrials? It can't be an unending process of retrials for sure. But I don't know exactly what that number is. I'll have to look into it. LK Ryden. Legalbytes, seeing John's family today, I wonder if the jurors that wanted to convict got stuck in getting justice for the family. That is something that can make someone not budge. Yeah, and that's one of the specific instructions that the court makes to them is like you can't convict because of sympathy for the family, and you can't acquit because of sympathy for the defendant. That's one bit of reasoning that is not allowed. But I mean, realistically, how are they going to know? Flashfan 85, Legalbytes, I can't watch a trial without commentary. That's why you're my favorite law tuber. Well, thanks so much. Ricky 12, question, do we know if the family has said anything yet? Must be difficult for them as well if they have to go through it all over again. I haven't seen anything about a statement by the family at this point. I doubt that they would anytime soon. I wouldn't blame them if they wouldn't want to. But yeah, that's rough. That's really rough for them to have to go through this all over again. I'm sure it's re-traumatizing every time they sit and listen to it. Kristen O, Legalbytes, it might have been good for them to try to soften Karen's persona. All jury heard was her jealous or screaming. Do you think she should try taking the stand next trial and explain? Ooh, I really don't think so. I don't think so. I think that if she had taken the stand, there's just too much danger with that. There's that can also backfire with her being it's such an outspoken person from the interviews that I have seen and her statements to the press, even during this trial. She's a pretty fiery, outspoken person that can very, very easily backfire with her on cross-examination. If Lally gets under her skin, for example, and she gets angry and she starts to say things that are even not necessarily like dishonest or bad factually for her case, but it puts her in a place where she just looks like maybe a bad person, that can be her undoing as well. Stella by the Sea, question, Bev rushed case to trial before FBI findings. Do you think she will wait next time? I mean, she would have to. I mean, there's no, I mean, well, not necessarily that she would have to. There is a time limit. It has to be done within the next year. But in terms of like the FBI findings, I think that from what I heard, the two sides wanted to wait. They wanted to push it back another month or 2 months or something like that. So, I mean, this case is not going to be retried in the next couple months. So yeah. LK Ryden, Legalbytes coming in late. Don't know if you've talked about it, but it's been said that John's brother said something to Karen afterward. Do we know what it was? Don't know. I'm sorry. Just Che things. Question: can the judge say no to a new trial? Nope, cannot. So no. Doctor Who 8675309 Legalbytes. Did you have to do the robot while reading like a robot? Yes, I did. No, but that would have been way more entertaining than the way that I was forced to read it. Divine Inhale with Donna Clifford. Question: can she get a restraining order against Paul for saying I'm not done with you? Oh, is that what it was? Did he say that? Yikes. I'd like to see some confirmation about that before really believing that myself. Not that I don't believe you, but if that is something that he said, that's very threatening for sure. But I think that for a restraining order, though, I think they might need a little bit more than that. Janet G. Legalbytes, it almost feels like a retrial is so unfair as the shock and awe is now done. There's no surprise shocker info now from the defense, but that's okay. I mean, that is very uncommon for a trial. Like most trials, both sides have all of the information, which, now the two sides can't argue, well, they didn't provide us this. They didn't provide us that. They didn't provide us this. They didn't provide us that. I mean, I don't know. Maybe the Commonwealth does in fact have more information that they've never provided to them, in which case there's a potential for a Brady violation argument by the defense. But the jury is still going to be fresh, with fresh minds and fresh ears and fresh eyes on this case. So the shocking information that we learned during this trial is going to be brand new to the jury, because by definition, they can't have known enough about this case to really be informed about the details. Rachel, Legalbytes, can the CW change their experts at all? Yes, they can. So can the defense. Flashfan 85. Although, I mean, with the medical examiners, I should say, reiterating, the medical examiner that those are the people who actually did the autopsy. So them changing those people out, that's a little skeptical. I'm a little skeptical of that one, because they would have to explain that. By the way, I'm ending the poll. We already know what happened. 66% of 2,200 people voted. It was a hung jury. That's ultimately what it was. Someone's getting sleepy with yawning. Not just kidding. Thanks, Flashfan. No, definitely not getting sleepy. Just forgetting to breathe when I talk too much. Alex025 question: do you think Lally will speak louder next time? I hope so. I sincerely hope so. Corey Murdy, Legalbytes, what about the people that perjured themselves? Charges? I don't see any perjury charges coming out of this case. There's been some dishonesty, it seems, but not rising to the level of a perjury charge. Ethan Morgan, question, comment. Thanks, Legalbytes. I agree that inflection can change the eating of a phrase, or maybe the sounding of a phrase. I think that might be a typo. Natalina Rose, Legalbytes, do you think if any of those police are arrested, that they will still go forward with charging her a second time? It sounds like it. It sounds like the DA is just dead set on this. Daniel Nagy, Legalbytes, do you know the statute of limitations for the charges? Do you see those being exceeded during a retrial? That would be the statute of limitations would have been told anyway. Told, like TOLLED, basically means that they're like frozen in time because of the fact that this trial had been pending, it had been ongoing. So that's not going to be an issue. Flashfan 85, Legalbytes, do you think KR will testify in trial 2 out of caution? I don't think so. I doubt it. James Games Classics, Legalbytes, her defense donations were on the way to £500,000 last I looked on donations page, so probably will be fine. I would imagine that now she would have even more supporters after this trial. Mountain Princess 207 question: how many in the chat have hit the like button? It really helps getting it out in the YouTube. Thank you so much for that, Mountain Princess 207, one of our other awesome mods, of course. So yes, if you guys are enjoying it, please do hit the like button. It does really, really help us with pushing this out to the rest of the YouTubes, as Mountain Princess says. Yeah, more eyeballs means more support for the channel overall. I mean, even if people are just watching and asking regular questions or just watching and lurking, all of that AdSense and everything, ad revenue, that kind of stuff does help to support the channel, which helps with all of the time and other resources that we've got to put into this. Sue B question: I feel like everyone is jumping the gun on a retrial. Did I miss something? What a disappointment for today. No, the DA said that they already announced that they are intending to retry this case. Let me see here. I think, where is, okay. Alrighty. Dragon 7398. Legalbytes, is the state allowed to present a different interpretation of how the crime happened if they go to trial again, or are they stuck with their current run? They're allowed to put forth a different theory for a brand new jury. The problem is, does that line up with the witnesses who have already testified without having to change their testimony? They still have a problem with medical examiner saying manner of death is undetermined. And they still have a problem with the lead investigator making a conclusion 16 hours in. So there are a number of issues that, regardless of how they change their theory, that there's a problem. Debbie Fizan Cook, recourse does the defense have if Trooper Paul gets up there and now knows all the physics he should have known the first time? I mean, the physics still don't explain how he got to the conclusion that he got to. So, unless he has some sort of a new set of answers where he talks about physics and he uses math and physics to reach his conclusions, that can still get torn up by an opposing expert witness. So, it's even if he uses math and science, it still has to be good math and science. Dayan Luich. Legalbytes, in the case that the case gets retried and a change of venue happens, how does that happen in terms of legal stuff, different states, etc.? It would still be the same state. It would just be a different county. So it just means that they bring in a different jury. It's in a different courthouse. In that case, it actually would be a different judge, but it would still be the same prosecutor. It would still be the same, potentially, defense team. Shiny Stones, Legalbytes, can the defense request for the retrial to be outside of Massachusetts, since it might be difficult to find jurors? I haven't seen anything about this case. That I don't think so, because that's the whole venue change. Venue refers to a different county within the same state. So yeah, I don't know of any case that has taken a case out of a particular state entirely because of a situation like that. Barbara Hartwell, Legalbytes, if the CW shows the Sallyport video again, will they flip it back to not inverted? That's another question. That's a very good question. That would be, I mean, either way, it's super sus, right? Erica Baker, Legalbytes, have you ever had a jury member assault someone because they got heated in the deliberation room? I have not heard of an actual assault happening during a deliberation. Larry Huffin, question: if in that statement it says that the Commonwealth intends to retry this case, does that mean it's going to stay there and the Commonwealth is going to retry it, or what does that mean? It means the Commonwealth will retry it. It could be in a different county if they decide to change the venue, possibly, but otherwise it's still the Commonwealth that is prosecuting the case, and it's still the Norfolk County District Attorney's Office that would be doing it. Dejan Lujic, Legalbytes, what happened with your interview with, what was it, Court TV or Law and Crime? I did, in fact, have an interview with Law and Crime about this case. I don't know what they have done with that. I assume it'll be coming out at some point this week, but I did talk about this case with one of them for one of their programs. And so hopefully that'll be coming up soon. I'll definitely keep you guys posted on that when I find out more. Flash Fan 85, Legalbytes. I researched the question of how many times a defendant can be retried after hung jury. It's as many times as the state wishes. There's been a bill issued to stop them, but hasn't been signed. Oh, really? That's insane. Dionysia Jaclo, Legalbytes CW announced a retry, even though we don't know the split. Bold move. I think so. I certainly think so. If it's 11-1 for an acquittal, that's a very bold move. Major question, can the judge impose a gag order on the jury? It can happen, but it's got to come with some process before that. That she wouldn't just like put a gag on them because there's First Amendment rights and all kinds of other issues. Oliver Olson, thanks so much for the super chat. Do you think a retrial would be postponed pending the outside investigations? It seems frivolous for the Commonwealth if people are found bad actors. It does seem frivolous. They can only wait so long, though, because they have to retry the case within a year of the mistrial. So that's a significant limitation. So, I don't know how long the FBI's investigation is supposed to be going on for, but I would imagine that significant information could be coming out in the next month or two. The Lucian Legalbytes question asking again. I don't think I heard if you answered. We know about directed verdict for guilty, not guilty. How does directed verdict work for hung? Not going to. The judge is not going to just come to a conclusion like on her own if the jury can't. So, yeah. LK write down, Legalbytes, the kids' testimonies were recorded, right? Does that mean they don't have to testify again? I think they've been through enough. It was recorded. Yes, it was recorded. They might still call them though. So because for the prosecution, it's like it's like, better to have live testimony rather than death by deposition, so to speak. So yeah, but that is a lot to be putting them through again. Sue B question, a retrial is crazy. The feds are involved. It's sad. Not only does this impact Karen, but the O'Keefe family. I can't imagine a non-tainted jury. I'm in New York. My husband had a conference call from, oh, shoot. I didn't get the rest of that before. I think that you probably had multiple, let's see here. Yeah. Multiple. Oh, wait, here we go. Had a conference call from people all over, and they were talking all about it. Yeah, yes, trying to find an impartial jury will be even harder this time around. Major question, can the judge impose a gag order on the jury? We got that question before, not without definitely some back and forth between the two sides. And yeah, that is a significant restriction to be putting on the jury's First Amendment rights. And Pity Pat Hamilton question, what happens if the FBI finds that the investigation by Canton PD was conducted unlawfully? What is the legal term for botched? What will happen to this trial? Is it too late to stop the train? I mean, so the FBI, they're going to do their own investigation, but they're not fact finders though. Like they're not judges, right? So they can, they're part of the Department of Justice, and the DOJ can put forward a case of their own in federal court to try a case like this over this, in which case there would be a judge who would be making a determination on it. And if that is the case, I mean, there's a big question as to like what could come in from that. Probably quite a bit would be very, very relevant. But that seems that would take a lot longer than a year. So I don't know that would end up making its way into the case here because of just the timing of all of that happening. So, but information that comes out, just like happened in this trial, if there's more, could come out in the next one. Flashfan 85. Legalbytes, we need Alita as KR attorney. Start the petition. No, she does not. She does not need me as her attorney. It would be interesting to be a consultant on for a trial team. That would be interesting. But no, they don't need me as another attorney on their team. Flashfan 85, Legalbytes, speaking of Lally speaking louder in trial 2, do you think the state will use a more aggressive strategy next time? I don't know that they can. Because they still have a lead investigator problem. There's a number of issues. Little Kobe question, do we already know what the split was? No, unfortunately we don't. Flashman 85 question, do you think they will refrain from calling Proctor in round 2? That's a very tough question because I don't know of any criminal case where you don't hear from the lead investigator. So it's just that's a big, and the defense can jump all over that too to say they didn't call their lead investigator. Why not? What is he hiding? There's a number of things that can be done to sort of indicate that. Kings and Queens, question 12 juries in 5 days. We do not know. Michael Proctor, 16 hours. She did it. Karen Reed, sorry for my misspelling. No worries. Yeah, I know. It's ironic, isn't it? Isn't it ironic? Don't you think? I definitely think it's a little too ironic. Yeah. It's not lost on me for sure. Let me really quick here, just make sure that I've got these. Okay. LK Raidan, Legalbytes' granddad was murdered when I was little. Oh no. And his case not being solved sometimes feels like a blessing watching these trials. Sometimes wonder if limiting family presence would be better for them. Yeah. I mean, but you also, it also would be bad for them to say like the family who lost the victim is not allowed to be here for the trial. Yeah, there are all kinds of issues with that, but I definitely understand, the whole process being totally like re-traumatizing on top of everything. And I'm sorry about your grandfather though. Kissable question, Legalbytes, do you think Lally is unprofessional to continue to pursue the charges despite the FBI accident reconstruction testimony? His professionalism. Yeah. But see, I don't know if that's different than his compatriots and his colleagues at the DA's office. Like there were things that suggested to me, I don't know. You can't make a conclusion about the whole based on one person, but I would also have a question as to how common it is for those kind of tactics to be employed in that office. So, if it's not him, maybe somebody else. For example, his second chair did make that terrible argument about Karen Reed's DUI lawyer Google search to say that that's somehow that is somehow indicative of Karen Reed's consciousness of guilt. Ridiculous. Flashfan 85, Legalbytes, did you do an interview with Vinnie Politan? No, it wasn't with him. It was someone from Long Crime. Mr. Waffles, catching up on the live, might it be that DOJ forced the DA to bring this case once it was underway to get those testimonies on the record under penalty of perjury? No, that's not something that would have happened. Debbie Faison Cook, Legalbytes, Peter said 6 months. Are Mass and Florida different? I think so. I say that with confidence because I actually literally came across a tweet by Andrea Burkhart. She looked up specifically Massachusetts law on this issue. And she said that it's like right just within a year. So it's Massachusetts Criminal Procedure Rule 36. Sets a default time limit of 1 year from the time the mistrial is declared. So that's what that was. So yeah, 6 months is a lot better for the defense. In Massachusetts, it's a year. Social mail question. Emily D. Baker said that the DA always says that they will retry, but may not go ahead. Wait for July 22nd meeting. What do you think? I mean, she worked for the DA's office in Los Angeles, so LA County DA. So I would definitely trust what she says about that. I would 100% go with her on that. So I can totally see that being the case. Flash Fan 85 question. Do you think Judge C will allow cameras for trial too? I hope so. I sincerely hope so. I don't know what Massachusetts is like in terms of like how camera friendly they are. So for example, New York and California, almost never going to see cameras in the courtroom. Florida, however, always. New Mexico, apparently very camera friendly. So I don't know where Massachusetts falls along that spectrum. However, considering how much public interest there is in this trial and seeing how many people, showed up to the courthouse, regardless of there being cameras in the courtroom, I think you'd have even more people showing up trying to go in person to see what's going on there. So I hope so. I hope there would be cameras. Cole Cooper question. If a witness from this case is unavailable for the retrial, is it common to use their testimony from the previous trial, or do they seek new witnesses? What's the process for that? It could be either one. I mean, if it's a lay witness, for example, and their testimony is crucial, they're gonna use their prior testimony. But if it's like an expert witness, for example, maybe get another one, I suppose. Yeah. The Lucian Legalbytes question is the time limit to retry is a year. Is that a year to refile charges, or retrial has to happen within a year? The deadline to retry is within a year. So in other words, not just and it's the same charges, by the way. So, they don't have to refile charges. They just have to set a new retrial date. LK Raiden, Legalbytes, just to clarify, seeing families believing the case. Seeing families believing the case and fighting for justice as a way to process their grief, knowing justice doesn't bring closure would be worse than not knowing, I think. Yeah, I can see that. I can definitely see that. Dr. Who 8675309 Legalbytes, that seems suspicious. Does it really? Does it seem?
Don't be suspicious. 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 Don't be suspicious.
John Ralphio?
All right. Of course. We had to play it. The Rubber Duck 77 Legalbytes question. Is it possible with this looking like an open and shut case for the defense? Could they have in their contract with Karen, they don't get paid if no acquittal, they equals lawyers? No, you can't have, there are certain rules for criminal cases, in terms of like what you can and can't do. Like you can't guarantee a verdict. Generally speaking, that's what I understand in California anyway. Yeah. Let me see here. I think there are a couple more. Okay. Let's see here. Gracie Precious. Legalbytes question. Oh my gosh, that's zooming on Indy right now. That's so cute. Does Karen get to walk free because it's a hung jury? She doesn't. She kind of sort of does, but also doesn't. She's still under the restrictions of her bond from previous, before going into this trial. So she can't exactly, excuse me, she can't exactly like go and like, yeah, I don't know what the exact restrictions on her are, but there are all kinds of conditions. She can't go travel outside of the country for sure, probably outside of the state. And there's got to be a number of other restrictions on her as well. So, but she's not sitting in jail. So that's good for her. Social mail. Question. Jackson said he will be there for retrial. Will the lawyers work pro bono? Probably not. I doubt it. I highly doubt it. But I don't know. Maybe they will. That's up to them, and that's their agreement with Karen. But it's a lot of work to be doing pro bono, even if it's just for the publicity. Like, yeah, that's a lot of work to be doing pro bono. Flashfan 85 question: do you think the defense will call more witnesses in trial too? I don't know. Part of that might depend on who the prosecution decides to call. Like, I really would have loved to have heard from the tow truck driver. I thought he also was possibly going to testify for the defense. So that's someone who I'm curious to hear from, but I don't know. I don't know ultimately if that would have been helpful. Sue B, I think this might be the last question. Haas, do you think the solo cups are holding up? You need some rest. Babies take a lot out of you. I called it baby brain. Well, yes. Haas, are the solo cups holding up? I don't know. I don't know. But yes, I definitely do. Definitely do need some rest for sure, but we are going to have a lot of content coming out this week on the channel as well. So not only resting this week, but definitely will be enjoying getting more rest than during the trial itself. Third trimester definitely kicks you in the butt. I've started to notice that already as well. Flashfan 85, Legalbytes, are you aware of the YouTuber Collier Landry? He testified against his father at 12. No, I don't know. Joey G17, question, I live in Mass. How would they find a new jury when this case is so popular? It's a really good question. Really good question. I don't know. They would have to have an even longer jury selection process. The Rubber Duck 77 question, I was on my phone heading into work. Did you see if the car didn't hit, you must have quit? No, I didn't see that, but that is perfect. That is perfect. LK Ryden, Legalbytes don't mean families not being informed would bring chaos, but being part of the process. They often connect closure to conviction plus DA equals their hero. Even with guilty, the grief is the same. Oh, absolutely. Absolutely. That on its own can't bring closure, but it can maybe help possibly. All righty, folks. Okay. That for me about does it. Thank you so much for joining me for this stream. As disappointing as that sort of climax is for this case, it's not the result that anyone really wanted, whether you are pro Karen Reed, pro prosecution. It's one of those that is just kind of disappointing, but hey, the case apparently continues. So journey continues. We're all in it together. So stick around and we'll find out what results. I will definitely be keeping track of that July 22nd hearing. That should be day one of the Ashley Benefield trial. So, but I'll definitely be keeping track of that as well. So we'll find out. We'll find out what happens afterwards. And the Lucian, this is one question that I definitely want to. Oops, sorry. Question, what is next trial? Alec Baldwin. When? Alec Baldwin starts on next Wednesday, the 10th. So, that's the next trial. And in between, we've got more content, not just trials. So we've got more other stuff. So, okay. All right, folks. From me and Indy. She looks like she's got broken parts that need to be reassembled. From all of us here, thank you so much for joining us on this whole long journey. It's been quite a crazy ride, but I appreciate you guys sticking around with me and watching with me and you know, engaging in the conversation and everything. So thank you so much for joining us. And yeah, I'll see you guys in the next one. Okay, guys. See ya.